Start. An absolute control, therefore, has been vested in the High Court over its staff, which would be free from interference from the government, subject, of course, to the limitations imposed by the said provision. Stop. There cannot be, however, any doubt whatsoever that, while exercising such a power, the Chief Justice of the High Court would only be bound by the limitation contained in Clause 2 of the Article 229 of the Constitution of India and the proviso appended thereto. Stop. Approval of the President / Governor of the state is thus required to be obtained in relation to the rules containing provisions as regard salary, allowances, leave or promotion. Stop. It is right that such approval should ordinarily be granted as a matter of course. Stop. Decisions of this court, as discussed herein before, in no unmistakable terms suggest that it is the primary duty of the Union of India or the concerned state normally to accept the suggestion made by a holder of a high office like a Chief Justice of a High Court and differ with his recommendations only in exceptional cases. Stop. The reason for differing with the opinion of the holder of such high office must be cogent and sufficient. Stop. Even in case of such difference of opinion, the authorities must discuss amongst themselves and try to iron out the differences. Stop. The appellant unfortunately did not perform its own duties. Stop. It has to be further borne in mind that it is not always helpful to raise the question of financial implications vis-a-vis the effect of grant of a particular scale of pay to the officers of the High Court on the ground that the same would have adverse effect on the other employees of the state. Stop. Scale of pay is fixed on certain norms, one of them being the quantum of work undertaken by the officers concerned as well as the extent of efficiency, integrity, etc. required to be maintained by the holder of such office. Stop. This aspect of the matter has been highlighted by this court in the case of the judicial officers in All India Judges Association versus Union of India and others within bracket 1992 1 SCC 119 as well as the report of the Shetty Commission. Stop. Having regard to the aforementioned authoritative pronouncements of this court, there cannot be any doubt whatsoever that the recommendations of the Chief Justice should ordinarily be approved by the state and refusal thereof must be for strong and adequate reasons. Stop. In this case, the appellant even addressed themselves on the recommendations made by the High Court. Stop. They could not have treated the matter lightly. Stop.
Start. In special civil application number 2.